Hello, friends, and thank you so much for joining us today as we talk about the amazing work that's being done here at the Quinney College of Law and elsewhere on campus and within the University of Utah and broader community dealing with our partners, Native nations. My name's Elizabeth Kronk-Warner, and I have the privilege of being the dean here. And my area of expertise also happens to be Indian law. So I'm really excited to bring my colleagues together to share all the wonderful work that they're doing as this November is Native American Heritage Month. And it's proper that we should begin today by acknowledging that this land that we're on today, which is named for the Ute tribe, is the traditional ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. And again, my colleagues are going to talk to you today about how they're really living that statement. It's not just words to us here at the Quinney College of Law. It's part of who we are and what we're committed to. And so they're going to share with you the great work that they're doing across. And I really love that, for centuries now, the Great Salt Lake Valley has been a place where people have come together, whether it was Indigenous peoples coming together to trade and barter and learn from one another, or it is as today as we talk about ways that we're working with our tribal partners in hope to making the world just a little bit of a better place. So just to give you an order for the day, and I'm just going to briefly introduce my colleagues so that we can spend lots of time hearing from them and their great work. So we're going to kind of start local with my colleague immediately to my left, Professor Brigham Daniels, and he is one of our co-directors of the Stegner Natural Resources Environmental Center, and he's also been doing a lot of work on our Great Salt Lake project. And so he's going to tell you a little bit about the project and how that intersects with the tribes here in Utah. Following him will be our Professor Beth Parker, who also happens to work on the Great Salt Lake project, but we'll be talking to you about another project that she's working on with our tribal partners related to health in the community. Then we're going to go to myself. I'm just going to give you a brief update. I did on Indigenous Peoples Day last month, I did an update on my research about originalism in Indian law, and we've had a really interesting decision, y'all, come out from Justices Gorsuch and Thomas since that presentation. So I'm going to give a brief update. Then we're going to go all the way down to the left, Professor Jackie Morrison, who runs our international law clinic here at the Quinney College of Law, and is doing really impactful and interesting work between tribes and First Nations in Canada and the United States, and issues affecting the border. And last but certainly not least is our OG professor on this panel, the longest on the panel from Quinney. So I'm going to call you the OG professor, and that is John Rupel, who's going to talk to you a little bit about how his work has been intersecting with tribes as well. And he's going to build off of Professor Morrison's work that she's been doing in the clinic. So with that, I'm going to hand it over to Professor Daniels.
Thank you. Thank you so much, Dean. And we're so pleased to be here with all of you and to mark this day. Just a few short words here about Great Salt Lake Project. Great Salt Lake Project is a project stood up by the University of Utah to answer a very critical question that's being asked in our community: how do we save Great Salt Lake? And we answer that question by providing detailed, actionable legal advice to willing policymakers who are willing to collaborate with us. So a lot of our work, it relies on water law, and I just want to kind of start by a little introduction here. And in some ways, what I want to do is tell two stories, and I have to say the first one is a real downer, and the second one is quite inspiring. So hopefully we can end on a positive note, even though what I'm going to start out with is really not positive, really at all. And that is, water law in a lot of ways is it was built to facilitate settlement of non-native people in this community. And that's true of water law in the West generally. In a lot of ways, what the law is basically doing in water, the same thing that we saw in land, which was displacement and then establishing a set of rights and then gating those rights over time. One thing to say about where we sit, Native peoples have worked, hunted, fished, lived sometimes temporarily, sometimes permanently in these valleys for millennia, and pretty much undisturbed until the mid-1850s. 1847, we had a first group of the Mormon settlers from the Church of Jesus Christ of Latter-day Saints. It's interesting, we mark our state holiday, or our first day of kind of that history, July 24th, 1847. And the first water right was actually established on July 23rd, 1847. It was diverted, water diverted near downtown Salt Lake. And we started to plant things pretty much right away. This really marked a very different kind of use of water. For the longest time, the water was used in stream. It was used in seasonal ways. It was used as habitat was replenished, fisheries were full, and that was the major use of the water. Of course, drinking water, but nothing like the irrigation that we saw. To kind of put a kind of drawing back that water law history from our broader history, I think that what we see in that history is that more and more settlers came, more and more folks got displaced, and one of the things that is really quite different about the rivers that feed Great Salt Lake particularly is that there was enough development in these valleys that when time came to maybe rectify some of the past and come up with a treaty and say, okay, you can live here or there, or here's a reservation, and I realize that that's a very complicated and unsatisfactory way for a lot of those stories to end. In this particular case, the folks that were here, native folks that were here, were pushed out so effectively that no water rights were actually provided on any of the rivers that feed Great Salt Lake. So that's a very big difference between, say, for example, Great Salt Lake's Bear River and the Colorado River. Water problems in native communities are extreme. If you happen to live on a reservation, you are somewhere between 19 and the Navajo Nation 67 times more likely to face water insecurity. Within some parts of Navajo Nation, in the Four Corners region, 1 out of 3 people don't have running water in their homes. They don't have any for even basic sanitation. At the same time, this relates directly to our project, the irrigation practices that were established by the settlers in large part make up the water rights that are starving Great Salt Lake from being refilled. And so this interaction has caused the decline of Great Salt Lake, and for those who are paying attention to the problem, 1,000 square miles, or roughly that, of dry lake bed is exposed, and that exposes, as a dry lake bed is exposed, as wind sweeps over it, those winds pick up dust, and this dust has all the pollutants that have been delivered there from either natural processes or man-made processes for centuries, and that pollution is being distributed across our community. And it's the marginalized communities, including our Native folks who live in marginalized communities disproportionately along the Wasatch Front, they're being affected more drastically than most others in our community. So that's that's sort of the really that's the sad story, or in a lot of ways, it's a story that doesn't have a lot of redemption. And maybe one of the lowest points of that story, if we were really going to drill in, it would be 1863, when something called the Bear River Massacre happened. The Shoshone, the Northwestern Band of Shoshone tribe, somewhere between 200 to, I've seen estimates as high as 500, but maybe 300 is maybe the midpoint, where you see one of the largest massacres in our nation's history occurred right here by the federal government. And it was interesting because what brought the federal government here was there was some tensions between the members of the Church of Jesus Christ of Latter-day Saints and the federal government, and particularly over the issue of polygamy. And these tensions brought the federal government here, and we don't really have stories of people that lived in the settling communities being slaughtered, but we do have this one with the bear at the Bear River. And that could really, if I'd stopped here, I think that we could all agree that that was a really terrible story to tell on a day like today. But the thing I want to point out has to do with Native stewardship principles. And there is a group of members of the Northwestern Band of Shoshone have purchased a large piece of property to commemorate what they would consider something like their Arlington Cemetery, a place where their ancestors are, their bodies are found. What they've decided to do is to try to restore that part of the river. They have removed a lot of invasive species, Phragmites, but particularly Russian olive. Both of these take up a lot of water. They are replanting these areas with native plants. And they also purchased a lot of water rights. At the end of this project, they anticipate that 10,000 acre-feet of water will be transferred to the lake. And to give you a sense of that kind of scale, that's about 1% of the problem. It would just be from that community. And you say, well, that isn't, that might not seem like a lot, but we're probably like 2 or 3% with all the efforts that we've done so far. So it's actually pretty significant. So just sort of in closing here to say, I don't think that we really took the time the settlers did not take the time to learn the lessons that maybe could have been taught at that time, but that community, particularly Northwestern Band of Shoshone, has basically provided a pathway forward that if we did that across the basin, that would be the way to save the lake.
Great. Professor Parker.
Thank you, Dean, and thank you so much, Professor Daniels. And I'm so grateful to be here today and to talk about some of the happenings, as Dean Cronk-Warner mentioned, at the law school to commemorate Native American Heritage Month in November. So what I'm going to talk about today is a relatively new center at the University of Utah. And this center is in partnership with University Health and the National Institutes of Health. It's called the Elevate Center, and it's a maternal center of excellence. And there are 10 of these maternal centers of excellence around the country. And this is part of the National Institutes of Health IMPROVE initiative. And IMPROVE stands for Implementing a Maternal Health and Pregnancy Outcomes Vision for Everybody. And this is so important. The Improve initiative aims to improve outcomes and equity in maternal health. And here at Elevate, this is a 7-year program here at the University of Utah, and we're in year 3 and funded through year 3, and very grateful for that. So one of the primary goals of the Elevate Center is to develop policies that can be scaled, that may start out small, but can be scaled and used more broadly and impact policy as policy is implemented and as we have health policies implemented. And as we were setting up the Elevate Center, we tried to look for sectors of pregnant individuals that were at high risk for death. And this particularly happens in the 4th trimester within the year after giving birth. And there were three sectors of pregnant women that were identified by the University of Utah Health to be part of this Elevate Center. And one of these sectors is our Native American population, which experience a higher rate of maternal mortality than non-Native mothers. And so as part of the Elevate Center, the center includes 2 research projects. One is called Improve, and I won't be talking about that today, but the other center is called the Ceremony Center. And in honor of Native American Heritage Month, I'll be talking about this center today. We also have 2 cores as part of the Elevate Center. One is a community engagement core that aims to really be led by community members, which is really novel and in the health sphere. And one is a training core as well to take what we've learned and be able to train others. And I have the honor of leading the Community Engagement Core. And as part of the Community Engagement Core, we bring together participants and community members from the Inspire portion of Elevate as well as the Ceremony portion of Elevate. And the Ceremony portion of Elevate, under this we are working with the Confederated Tribes of the Goshute Reservation and a 638 contracted healthcare facility called Sacred Circle. And just a little background on 638 clinics. So these are healthcare facilities that are operated by tribes. And this is done through the Public Law 638, through the Indian Self-Determination and Education and Assistance Act. And this legislation allowed tribes to manage their own health care. Under this, the Confederated Tribes of the Goshute Reservation has established Sacred Circle. And I do want to read a quote that Sacred Circle has on its website. And I encourage everybody to go to the Sacred Circle healthcare website to learn more about this amazing facility. But like I mentioned, this is a federal 638 owned and operated clinic, and they are dedicated to complete care without discrimination, and founded on a commitment to relationships and the Goshute tribe's tradition of healing. And this healthcare facility was started in 2012, and it is proudly owned and operated by the tribe. And the center preserves Goshute heritage, and this heritage includes protecting and caring for family and extending that tradition to not just tribal members, but all underserved populations in the local communities. And there are non-tribal members that come into the healthcare clinic as well. And so at Elevate, we have a memorandum of understanding with Sacred Circle. And our memorandum of understanding states that the University of Utah Health respects and honors the sovereignty of the Confederated Tribes of the Goshute Reservation, Reservation. University of Utah Health acknowledges the importance of community-led and community-engaged principles to guide collaborative activities. U of U Health explicitly acknowledges Confederated Tribe of the Ghost Chute Reservation and Sacred Circle Healthcare's rights and obligations to oversee health and other data of tribal citizens and patients of Sacred Circle, particularly when the data is used for research. And so this is our foundation of cooperation on which our relationship is built with Sacred Circle. And as part of Sacred Circle, we have a couple of different aims that we are working on in tandem with Sacred Circle. And our first aim is to adapt a model, a perinatal model that is culturally integrated for Native mothers. And the interesting thing about this is when we began, the model that we wrote up doesn't look like the model that we have today. And so we are in year 3, and we've been working closely with Sacred Circle and with community members. And what we've learned as we have as we have created this model, this perinatal care model, is that rather than a large data-driven model, community is the thing that is important. And so Sacred Circle, together with researchers at Elevate, have identified 3 different baskets of community. And the perinatal care model is based off of these 3 baskets. And together, all of these are woven together to try to create a legacy of healing for pregnant and postpartum mothers. And it has been such a beautiful thing to see this evolve. And as part of the ceremony center, our second aim is to assess the process and see how it works, and to see where things have pivoted, and then to provide patient-centered outcomes at the clinical level. And so we are about to launch this clinic within Sacred Circle Healthcare in February, together with a manual that will be scaled and can be replicated as well. And this really is community-driven. One thing that we have done at Elevate and at Ceremony is to be inspired by the National Academy of Medicine's model of community engagement. And what this does is, through community and community engagement, we are able to improve health outcomes, which is so important, particularly for our tribal communities. And one thing that we have been doing with our ceremony and Inspire project as well is we engage with our community partners, and we try to do it at an equitable fashion at every stage. And what we've learned is we do have to pivot and change along the way, and that's been such a great thing. And our partners, I'll just end by mentioning some of our partners, but they include organizations and individuals across a spectrum of healthcare advocacy group and people with lived experience. And I've mentioned Sacred Circle that we partner with through Ceremony. We also partner through our community engagement core with 4 Points Health, with the Paiute Indian Tribe of Utah, with tribal elders and Native perinatal health advocates, and the Utah Division of Indian Affairs, as well as the Utah Department of Health and Human Resources. And they work closely with us, so our findings can be turned into policy. And we're so grateful for our partners at Sacred Circle and all of our partners at Elevate. And thank you so much.
Wow. I am so impressed. Like, we're only halfway through the panel and I've already learned so much. I mean, my colleagues are just amazing, and the work they're doing with our partner tribes is so amazing. By way of reminder, we are taking questions. So if you have any questions, you can go to slido.com, SLIDO.com. And the code that you can put in and the questions will come right to us is hashtag ULawCLE. So ULawCLE, and we will be happy to answer your questions as we are able to. So I wasn't going to interject myself because I had the chance to talk about my current research project with Isaac Santos, who's one of our wonderful 3L students, earlier during Indigenous Peoples Month, or Indigenous Peoples Day, excuse me, last month. But something really exciting happened in the last week. So I'm kind of inserting myself into today's presentation to share with you as an update. So if you're interested in this topic, I know that the video of originalism and Indian law is available on our website, and you can read it there. And I just want to give a quick supplemental update to that presentation. Again, big thank you to Isaac Santos for his help in working with me in this project. This project really seeks to answer the question of whether originalism, if applied within the arena of Indian law, would actually get us the quote-unquote right result. And so I think that's where I'm going to go in this research together with Isaac, is concluding that originalism can be a very helpful framework to look at these decisions. And what I want to share with you is that just on November 10th, Justices Gorsuch and Thomas, in a dissent from a denial of certiorari, really applied an originalism framework to a pretty well-established doctrine in Indian law in a way that I think is consistent with where our research is going, and is exciting to me to see how they're applying originalism. So specifically, the case there is Quinton versus Venno versus the United States. Again, this is a dissent from a denial of certiorari that Gorsuch authored and Justice Thomas joined. And there, the petitioners were specifically asking for the court to look at the doctrine of plenary power, which was first articulated in a case, United States versus Kagama, from the end of the 19th century. And that case generally holds that Congress has plenary authority to act in Indian country. And it's on the basis of this case and that holding in United States versus Kagama that a lot of congressional action has subsequently occurred within Indian country. And Justice Gorsuch says in his dissent that, quote, it, which is the plenary power, is a theory that should make this court blush. Not only does that notion lack any foundation in the Constitution, its roots lie instead in only archaic prejudices. So he dissents along with Justice Thomas from denial of cert because he thinks that the U.S. Supreme Court should reconsider United States versus Kagama and the plenary doctrine and ultimately find that it is unmoored from originalist interpretations of the Constitution. He goes on to say that as sovereign and independent states, Native American tribes have governed their internal affairs from time immemorial. And so as a result, the plenary power and the ability of the federal government to intrude on the internal relations of tribes is not justified by a consideration of the Constitution. Specifically, he says that the plenary power in the Kagama decision was a sweeping assertion of federal power, one that would be unthinkable elsewhere in the United States. And he then goes on to show how in the Constitution, while the federal government does have some ability to enact laws that relate to crimes, in general, the police power and the ability to regulate crimes has been left to the states, and it's not a power that the Constitution has. And at issue in Kagama, I should say, the central issue is the Major Crimes Act, which allowed for the federal government to have jurisdiction over major crimes committed in Indian country. So he and Justice Thomas explained that this idea that the federal government has the ability to intrude into the affairs of tribes is completely inconsistent with the understanding of tribes as separate sovereign nations at the time that the Constitution was written. Additionally, he goes on to say that Congress's limited and enumerated powers no more include some plenary power over internal affairs of tribes than they do over the internal affairs of states. Then he goes on to point out that the Kagama court basically admitted that, saying that really we can't find anything in the Constitution that would give Congress this authority, because the best we have is the Indian Commerce Clause, which gives Congress the ability to regulate commerce with the tribes, and that doesn't seem to extend to the ability to enact the Major Crimes Act. So then the Kagama court went on to talk about the Territories Clause of the U.S. Constitution, but again, Gorsuch and Justice Thomas disagree with this. According to them, the Territories Clause of the Constitution, quote, does not authorize Congress to exercise municipal jurisdiction over non-federal lands within a state or over another sovereign exercises of authority. And so therefore, it does not make sense that Congress would have the authority under the Territories Clause to do this in Indian country. Next, they point out that in the Kagama decision, the court left behind the Constitution, moving to the doctrine of discovery, and seemed to suggest that the doctrine of discovery justified the plenary power. However, Justice Gorsuch explains that, quote, our Constitution makes no mention of that doctrine, nor at least as conceived by the Marshall Court shortly after the nation's founding, does the doctrine imply plenary federal power over internal tribal affairs. So if we look back at the Marshall trilogy of cases where Chief Justice Marshall and his colleagues then on the Supreme Court at the beginning of the 19th century really delve into this question of what is the doctrine of discovery and how does it apply, nowhere does it say or suggest that the federal government would have plenary authority in Indian country. Then Justice Gorsuch goes on to explain that, quote, lacking any other way to uphold the act, the Kagama court ultimately resorted to an archaic colonial prejudices nowhere found in our Republican Constitution and wholly antithetical to it. The Major Crimes Act, the court insisted, should be left to stand because Indian tribes are the wards of the nation and communities dependent on the United States for their daily food. He goes on to point out, and they both point out in their dissent for the denial of cert, that this is completely unmoored in the Constitution, is not consistent with an originalism understanding of the meaning of the Constitution at the founding of the United States, nor with an early U.S. Supreme Court interpretation of how the Constitution gave powers to the federal government over tribes. And so therefore, both Gorsuch and Thomas would have granted cert to take up this question of plenary power in the Kagama decision. So really interesting dissent from a denial of cert, and I think certainly supports the work that Isaac and I have been doing to look at whether originalism is a viewpoint that we should take into consideration when interpreting Indian law. So with that, I'll turn it over to our OG professor, John Ruppel. Or was it Jackie? Okay.
Great. Well, thank you. Hi, everybody. It's great to see you all, and thank you, Dean Cronk-Warner. It's an honor to be with all of you and to be able to share some of the great work the Stegner Center is doing in cooperation with tribal nations and the work we're doing with the International Law Clinic. Working with tribes truly is some of the most important and gratifying work we do, and I'm really honored to be here. Professor Morrison is going to talk about the International Law Clinic's work and how they're helping tribal nations address mine pollution. But before she does that, I want to pull back a little bit, give some context, and maybe tell the origin story of these efforts. So thanks in part to support from the Dean, I was able to take a leave of absence in 2022 and to 2024 and serve in the White House Council on Environmental Quality. Strengthening partnerships between the United States government and tribal nations and affording tribal governments a meaningful voice in resource management discussions, those were pillars of the Biden administration's priorities, and they infused a lot of the work we did at CEQ. One project that I'm especially proud of and of being involved in involved forging an international agreement between the United States and Canada to improve the quality of water flowing from the Elk Valley in British Columbia into Montana and Idaho. If you're not familiar with the area, the Elk Valley is home to some of Canada's largest coal mines. Tailings from these mine sites leach selenium. Among other pollutants, those pollutants end up in the Kootenai River. The Kootenai River flows across the border into Montana, over into Idaho before turning back into Canada and joining the Columbia River. The selenium, as you may know, is a really powerful neurotoxin. It's harmful to both humans and aquatic life. Selenium levels in the Kootenai River have exceeded water quality standards for years. They continue to rise, and that elevated level of selenium is attributable primarily to coal mining in the Elk Valley. Native American tribes are among those most at risk from selenium contamination because selenium interferes with their right to use a river and a landscape that is integral to the lives and cultures of multiple tribes and Canadian First Nations. Among other things, elevated selenium interferes with fish reproduction. Fish in the Kootenai River and the watershed those fish inhabit have since time immemorial been really central to the culture of multiple tribes on both sides of the U.S.-Canada border. So a collapse in native fisheries, which could result from mine waste, would devastate tribes. It would devastate their members, and it would devastate everybody that calls the basin home. Members of 6 bands that comprise the transboundary Ktunaxa Nation and the United States have long encouraged Canada and the province of British Columbia to increase mine oversight and to reduce selenium releases into the Kootenai River. Unfortunately, those efforts were, until recently, largely unsuccessful. Stepping back, under the Boundary Waters Treaty of 1909, the United States and Canada agreed that, and I'm quoting here, waters flowing across the border shall not be polluted on either side of the river, either side to the injury of health or property on the other. But this treaty, like many other agreements, it's not self-executing. And recognizing that disagreements are going to arise, the Boundary Waters Treaty established a process for resolving water-related disputes. The treaty, among other things, sets up what they call the International Joint Commission, or IJC, which is charged with investigating transboundary issues and recommending solutions when requested to do so by the U.S. or Canada. But the Boundary Waters Treaty is a document from a prior time. It's silent as to the rights of Native peoples who are not parties to the treaty. It also lacks a mechanism for the tribes to seek redress for injuries, leaving it to Canada and to the United States to advocate on their behalf. Overall, the treaty has probably worked pretty well, at least when we're talking about shared waters of the Great Lakes region, where Canada and the United States are on a comparable footing with respect to pollution and to its impacts. But the treaty has proven to be somewhat more difficult to implement in the West, where rivers and the pollution they carry typically flows from Canada south into the United States. So more of it flows south than north. And because of that, I think Canada has been somewhat understandably reluctant to support IJC engagement that could result in really heavy pollution control burdens, especially when those burdens would fall primarily on parties north of the border. But without Canada's support, there was really little reason for us to believe that the IJC could be engaged meaningfully and that efforts to address pollution in the Kootenai watershed would do anything but continue to languish. So the key to moving forward was to make sure that Canada joined the U.S. in requesting IJC assistance. Things began to change in March of 2023 when President Biden and Prime Minister Trudeau jointly announced what they said, and I'm going to quote again, I apologize, this is a little longer, but they said they intend to reach an agreement in principle by this summer to reduce and mitigate the impacts of water pollution in the Elk-Kootenai watershed, in partnership with tribal nations and Indigenous peoples, and in order to protect the people and species that depend on this vital river system. Now, this statement, it came out in a joint statement, but it was really remarkable for a couple of reasons. It was pivotal because, first, it signaled a willingness on the part of Canada to meaningfully engage and to do so on a defined timeline. Second, the commitment to partner with tribal nations marked a significant departure from past practice and a willingness to go beyond the narrow language of the Boundary Waters Treaty. So, due in large part to sustained, sorry, I've got a cold, I'm all clogged up. Due in large part to sustained pressure from the six bands of the Ktunaxa Nation and the United States, Canada agreed in 2024 to seek IJC assistance in developing a plan to reduce selenium levels in the Kootenai River. This agreement was only possible because of leadership and sustained advocacy by the Ktunaxa Nation. Lawyers from the nation were not only sophisticated and tireless advocates, they also kept the parties at the table and used the media effectively when progress slowed. If it hadn't been for the tribes, we wouldn't have been able to push the agreement forward. But, I mean, I have to also acknowledge that they didn't stand alone. I'd be remiss to fail to acknowledge the hard work, the careful work done by federal civil servants, staff from the White House, the State Department, the EPA, the U.S. Geological Survey, and other agencies spent months negotiating a really carefully worded agreement that I believe is grounded in science, that's faithful to the law, and is both aspirational and implementable. I'm happy to report that the framework is being developed to address selenium contamination, and while it's only one part of a much larger effort, it's an important step in a journey. And engaging with the IJC is really a path-breaking success, in my opinion. Tribes in Southeast Alaska, they've shown significant interest in using the Elk-Kootenai as an example and as a model for addressing proposed mines in northwestern British Columbia that would then flow into Alaska and potentially endanger salmon species. Tribes in Washington State, they're doing the same. So shortly after returning to the College of Law, Professor Morrison reached out and she asked me, could I help in trying to identify potential partners for this newly established international law clinic? And, well, Jackie can tell you more about that in a sec. All I'll say is it was easy and we have some tremendous partners. And Jackie, do you want to pick up on it from there?
Okay, I'll pick up on it from here, but I'd invite you to chime in, okay? Because we are collaborating on this project. So I'll back up a little bit, and first I want to say thank you. I have some thank yous to say as well. One, it's an honor to be here participating in this panel. And huge thanks to Dean Cronk-Warner, one, for inviting me to participate, but also for your support of this clinic. The International Law Clinic was a brainchild of mine that I had dreamed of launching, and I appreciate you allowing the space for that to exist at the College of Law and for your support of this work. So thank you.
It's easy to do because you're doing great things.
And I want to thank Professor Ruppel here, my partner on the very first project of the clinic, a clinic that will continue and be ongoing. So Professor Ruppel and Professor Plune of the Law and Policy Project have been wonderful collaborators. It's such a pleasure to work with you. And then I also want to thank Professor Brigg Daniels and Professor Lincoln Davies as the co-directors of the Stegner Center, who are also very supportive of this work. So all of that, but a little bit more background, why an international law clinic might be part of a panel conversation here today. International law and foreign law and comparative law, I think, are so highly relevant in today's interconnected and global world. We talk about concepts broadly like business and trade, war, peace, human rights, the environment and various environmental crises, and the impacts of all of these things on people and on communities. And with all of that, I really hope to create a space for our students to explore all of these complexities, and while doing that, gain hands-on real-world experience. So that was the kind of the behind the scenes, but when I first thought of the idea, I was so open, and I think it's very interesting that synergistically, all of the clinic's projects revolve around Indigenous rights. Both current projects and the projects looking forward. So I'm really honored to do this work and to be in this space. I launched the clinic in January with 5 students, our early adopters. And this fall, we have 6 students in the clinic and 2 advanced students. And then in the spring, 6 new students and 4 advanced students, and a lot of student interest in this work. So coming back to Professor Ruppel, and picking up on the story, one of the pieces I'm really curious about in international law, so if we talk about public international law, we're talking about the relationships between and among states, but who has a seat at the table? Whose voices are heard? And looking broadly at the Indigenous rights movement, we see some shifts in that landscape, in the traditional notion that it's only states that are parties to these conversations. And when we look at the joint reference to the International Joint Commission, we see the US federal government, we see the Canadian federal government, but we also see other voices being brought to the table. And for the first time, a joint reference established a governance body made up not just of representatives from the states, the governments, but also of tribes and First Nations. So we see the Ktunaxa people represented as an equal seat at the table in these conversations. So it's really groundbreaking what this joint reference has accomplished. And so as part of our, one of the first clinic projects coming out of the International Law Clinic was partnering with Professor Rupel, Professor Plune, and the Law and Policy Project on supporting tribes and First Nations in exploring the impacts of mining operations on their rights. So you spoke about mine waste. There are, and the coal mines, primarily in British Columbia, and the selenium that we see in the rivers, what legal avenues are available to tribes and First Nations to assert their rights? The devastation caused on the environment by these operations. We met with industry executives, talking about the ways in which they want to incorporate feedback from tribes, First Nations, from environmental consultants. We had the opportunity to interact with tribal elders, tribal knowledge holders, tribal youth, tribal leadership. We also got to interact with representatives from the US federal government, the Canadian federal government, and state and provincial governments. All our students got to experience all of this in a week. It was pretty amazing, and I think we've heard students say it was a transformative experience all around. And so it's with thanks to John for teeing up the project in the first place and making it possible. This work continues, and new work will evolve from here. The Pacific Salmon Treaty, which is another bilateral treaty between the US and Canada, is actually set to expire in 2028. And the Pacific Salmon Treaty does an immense amount of work to protect salmon stocks that tribes and First Nations rely on for sustenance, for other aspects of their way of life. And so bringing voices to the table as maybe those negotiations are happening, we're very interested in kind of continuing that work. In addition to the work with, and do you have anything else to add before I go off on another?
I think that's fantastic, and I mean, to give credit where credit's due, you took an idea and really ran with it and built a tremendous program. It's also interesting, Dean Kroc-Warner, you talked about Isaac. He's also in the clinic. So there's a lot of interest on all sides around these issues.
And another project that the clinic is working on, with thanks to Dean Kroc-Warner, our school is partnering with the University of Kansas's Tribal Judicial Support Clinic on creating a series of training modules on Indigenous rights under international law for the the United Nations Institute for Training and Research. So we've been working with the Division of Multicultural Diplomacy, building out a series of training modules. 3 of our students will be traveling to New York in a week and a half to present at UN headquarters to UN diplomats, other UN employees, staff, etc. This particular presentation will be on the UN Declaration on the Rights of Indigenous Peoples and the various mechanisms that support Indigenous rights under the United Nations. So really excited to do that work. Yes? Oh. And and just broadly, the clinic thinking about concepts like sovereignty, self-determination, doing a lot of research in the space of free, prior, and informed consent, and what meaningful consultation looks like. So I'll leave it at that.
Wow, I want to be in the clinic. That sounds so fun. That was amazing. I'm just so impressed with everything that you're doing. So we did start a little bit late, so we're going to go about 5 minutes past the hour so that we can make sure that you get your full 1 credit CLE and report that honestly to the bar. But we've got questions now, and we've had several really great questions come in. And just by way of reminder, if you'd like to ask a question of any of our panelists, you can go to slido.com, SLIDO.com, and it's hashtag ULawCLE. Hashtag ULawCLE. All right, so thank you for the great questions that have already been asked. So first, and this is, I think, open to all of our panelists if you have thoughts. For someone without a law degree who wants to advocate for Native American tribes and people, what resources or organizations can help support these efforts?
Wow.
Dean Cronk-Warner, I can start. So before I joined the law school, I was general counsel and special counsel to a number of tribes here in Utah and beyond. And there's so many ways to get involved. One way is to reach out to a tribe directly, see what you can do to help. I know there are many tribes that have a whole host of activities that they're involved in and love to have people come and get involved. For instance, many tribes have powwows that people can come and get involved in. And once you begin getting involved in a community, you can find ways of being a partner and an advocate. And as far as the ceremony pillar of the Elevate Center here at the University of Utah, you could get involved through the Urban Indian Center of Salt Lake. They're one of our partners. Or go down and check out Sacred Circle. If you're in the healthcare sphere, there's lots of help that is needed, and plenty of ways that can help. But I'm also part of an organization called Utah Tribal COVID Relief. We founded this during the COVID pandemic, but have continued this project along with a former professor here at the University of Utah to work alongside tribes, and we have a holiday drive that we do. So there are lots of things that you could do to get involved.
I want to pick up on that real quickly. I think Dean Cronk-Warner opened with a mention of the treaty clause of the U.S. Constitution. And to me, that's an important reminder. When we're talking about tribal nations, we're talking about sovereign entities, and we have to respect that. I think this is a moment where it's valuable to remind our government representatives at all levels that there is a legal obligation to engage with tribes in meaningful ways. So that's one place I would look. Another point I want to make, and I think this goes to something Professor Daniels said in his opening remarks and Professor Morrison both said. We don't speak on behalf of tribes. They're sovereign governments, they speak for themselves. Our job is to help them navigate a very difficult and complicated legal system and governmental structure. So I say that because I think it's really important as we think about engagement, what our role is and how we develop the relationships that are necessary to advance those ends. So it begins with building relationships.
This is not what the questioner asked, but if anyone is interested in getting involved in the Northwestern Band of Shoshone's restoration project, there is an organization called Grow the Flow, growtheflow.org, where you can sign up for that. They have service days out there where the tribe welcomes folks in to help with the plantings. It's one of the most well-attended service projects that organization puts on. So it isn't exactly what the person was asking, but it's a good time, and I would welcome anyone to participate.
I'll just add, if you're kind of interested in these issues at a national level, the National Congress of American Indians is an organization of over 200 federally recognized tribes, and they are regularly involved in a lot of the issues that we've mentioned here today in terms of environmental, sovereign issues, healthcare issues, and so that's also a great resource to get involved with if you are interested in. All right, so I think this next question is for Professor Parker. Is the funding from NIH for the healthcare program at risk?
Well, we were funded for year 3, which we were very excited about. Year 3 started this July, and we're taking each year one at a time. So hopefully not. This is such a really important program that we've been able to stand up, and it took years to build the foundation for this program, and then to be able to secure this grant. And we are, walking down this path with our tribal partners and our other partners at Elevate. So we certainly hope that we have showed enough progress to be able to maintain funding, and so far we have been able to do that.
And I'll just mention that there's a 1974 case, Morton versus Minkari, which held that being Indian is not a racial classification, it's a political classification. And so therefore, a lot of the funding, the federal funding that's been removed for quote unquote racial programs or programs that promote individuals with racial identities doesn't apply in the Indian and tribal context as well. So, and we've seen President Trump has expressed support for Indian self-determination and for maintaining commitments where the federal government has undertaken those commitments. So Indian country is a little bit different than some of the other populations that are being impacted. So I think the next question, I can start off and then would love to have you join me. So the question is, are there cases in the pipeline that could be impacted by the case the dean discussed? Where do you see the dissent leading? So what I think is really interesting about this is who joined and who didn't join, I think was fascinating. So Gorsuch is no surprise. Gorsuch has been, he came from the 10th Circuit, he understands Western issues, he understands Indian law, and really has been a proponent for getting back to foundational principles of Indian law. Justice Thomas was interesting. I was very surprised to see him sign on to this dissent. And I think is telling in terms of how he has expressed concerns with resolving kind of this inherent tension in Indian law, which is you have both tribal sovereignty and you have federal plenary power, and how can those two things coexist? And he's expressed that concern before, but it was interesting to see him explicitly support the assertion that perhaps plenary power is the one of those two things that should go away. But what we don't see on this dissent is interesting. We don't see Sotomayor. Sotomayor has been a proponent of tribal sovereignty since she joined the court. And of course, we don't see other justices as well. So where it's going to go will be interesting. I think that Gorsuch in this dissent is laying the framework for an originalist interpretation of Indian law. But where, I think the rubber hits the road where it becomes complicated is, okay, maybe in terms of the plenary power in the United States KGMA, it gets, and I should say I'm talking from the bias of promoting tribal sovereignty. It might result in an outcome of promoting tribal sovereignty by saying that the court should have never recognized plenary power. But then we have to think back on all of those congressional actions that have been passed as a result of congressional plenary power. So Professor Parker's example, for example, she was talking about 638 contracts and self-contracting. Would the federal government still be able to engage in self-contracting activities in Indian country if the ability of Congress to act under plenary power were to be found unconstitutional? So on the one hand, it's this big issue, which I'm so excited to get into and really think deeply about, of whether or not a win in striking down plenary power for tribal sovereignty could ultimately, at the end of the day, maybe be disastrous for tribal sovereignty in terms of other federal actions that have happened. All right, so next question I'll open up to all of our panelists. So what are your view of the U of U's continued use of the Ute name for its athletic teams? Could the U continue to pay the Ute tribe and discontinue use of the name?
I'll wade into that. I'll take the first part of the question. I feel like the question really is for the Ute tribe more than it is for the University of Utah. And I will defer to them. If we have an arrangement and if the tribe feels that we are honoring the name, honoring their tribe and their history, then I see no reason not to proceed. But I would want to know what the Ute Tribe of Indians is thinking, and I defer heavily to them.
Yeah, this is a hard one, and part of it I think is my sensitivities might say, yeah, we shouldn't do it, but we shouldn't use the name. But I think that if you take sovereignty and self-determination seriously, you really need to. I think you really need to fall where John fell, and so I don't know. I don't have much of a hot take, but I am conflicted.
Yeah, I agree. I personally think, that's kind of the rub of tribal sovereignty is that tribes have the right to make the decision. And where this really becomes complicated and kind of gnarly is I've been to football games where offensive posters have been held up in relation to the Ute tribe. But I have also visited the Ute tribe and know that there are many, I don't speak for the tribe, but many of the people that I chatted with were very proud that the University of Utah was using the Ute name, and we're excited to have the memorandum of understanding with the university. In fact, we just entered into another MOU this year in 2025. So I see where folks are concerned about using tribes as mascots, but I also, certainly agree with everything that's been said about the tribe's right to make that decision. So unfortunately, that's all we have time for. I'm so very sorry that we don't have more time. Thank you so much for spending an hour with us. And again, our way of celebrating Native American History Month, it's not just words, it really has impact for us here at the SJ Quinney College of Law. And we appreciate you taking the time. Feel free to reach out to any of us if you have any questions about anything we've discussed today. And I hope that you have just a wonderful holiday season coming up. Che Miigwech, thank you very much.